Bumper cars. Hey, we've all seen them. They're at amusement parks and they bang into each other. But what happens if they bang into each other and somebody gets really hurt? Does that person have a claim against the bumper car park? Well, that takes us to this week's case. It involves a real case involving real people. A mom, she was out with her 10-year-old son and they were at an amusement park where there were bumper cars. Well, she gets into the bumper car with her son and bang, they run directly into another bumper car head on. She saw that they were going to bang into this other bumper car and she reached out, braced herself, and then when they actually collided, she broke her arm. So she sued the park that maintained the bumper cars, saying, you guys should not have had bumper cars that could have head-on collisions. And therefore, I got hurt here because essentially you badly designed this bumper car amusement. Well, it went forward, and it went all the way up to the California Supreme Court. And there the California Supreme Court looked at this and analyzed assumption of the risk. Now, we've all heard the term assumption of the risk, and what does it really mean? It means that when you're involved in an activity that is inherently dangerous, you assume the risk. It's generally used with regard to sports. I mean, when you're playing football, you know you're probably going to get hit. If you walk into a boxing ring, you know you're going to get hit. That's the way the sport is conducted. Therefore, you assume the risk of that kind of injury. But in this instance, where you've got bumper cars that are going to bang into each other, is there a situation where you've assumed the risk? Well, the Supreme Court came away in California and said, yes, there is. These are bumper cars. They bang into each other. And in this instance, we didn't see anything in any of the facts that showed the plaintiff, the person bringing claim, was contending that it was unusually dangerous, that there was something other than low-speed collisions that were taking place. I mean, somebody could observe this before they ever got into a bumper car. They could see the little bumper cars out there banging into each other and know that that's what's going to happen. So when they get into that bumper car, they know that that's what's going to happen. And since there is a complete understanding of what's going to happen, when it happens, well, they can't complain because they have assumed that risk. Okay. So what did we learn here today? What we really learned is how assumption of the risk works. You have to be in a situation where you're engaged in an activity that you know what's happening. Now, I gave the example of a boxing ring. Obviously, you get into a boxing ring, you know you're going to get hit. But you don't expect the guy to have brass knuckles under his boxing gloves. And if he does, okay, that's unfair. That's not an assumed risk because it was unknown to the person who was participating in the sport. But if the risks are known and you go forward, you have assumed those risks, and accordingly, you get banged up, and that's life. Okay, we bring you this cases, we bring you cases every week so you understand how the law works. I'm David Allen.